Awesome. Mic on? Yep. Cool. All right. So let's get started. We got a lot to cover. So like you said, I'm Noah. That's my Twitter and everywhere else. I work at SAP on open source operations tools, but that's not super relevant here. I am required to give you a couple of disclaimers. The first, I am not an attorney and nothing here is legal advice. This entire talk is for entertainment purposes only. Please talk to a patent attorney or other licensed attorney if you have any specific questions about anything I'm talking here today. No, really, don't do anything in a court of law based on something a guy on stage says. And second, this is going to be US-centric. Intellectual property laws and customs vary around the world. Again, speak to an attorney in that country if you have questions about somewhere that's not the US. This talk is going to cover a lot of topics. Basically, every single subheading I talk about can be an entire career in intellectual property law. So I'm happy to answer any questions afterwards, but I'm not going to be able to go super deep into anything. Disclaimers out of the way. Let's start at the start. What is intellectual property? First, we need to define what is property. For the purposes of law, property is defined as an object over which you have certain exclusive rights. So for example, if you own some land, that means that you can control who builds on it, who walks through it, etc. Certain rights may be superable at certain points, or they may not apply in all cases, but in general, this idea of exclusive rights is mostly what we mean by property in law. So back to IP, literally speaking, this is just property that is intellectual. So let's say you paint a painting. You probably own the physical painting. You can sell it to someone, you can rent it to a gallery, you can burn it if you want to, but you also have some rights over the abstract intellectual work that you did that is manifested as a painting, in addition to the physical object itself. Before we jump into what intellectual property looks like today, let's talk a little bit about where it came from. For the tradition that became US intellectual property law, it pretty much all started in 1624 in England. Patents had existed before then, but they were these sort of one-off decrees by the king or queen, granting total monopoly control over entire industries. And as you might expect, they were deeply unpopular. So this law, the Statute of Monopolies in 1624, transferred control over patents from the monarch into the English Parliament. This helped to formalize the process and ensured that the patents remained temporary. This was revisited again in the Copyright Act of 1710, more commonly known as the Statute of Anne. Whereas the Statute of Monopolies was concerned with monopolistic control over entire industries, the Statute of Copyright, or the Copyright Act, the Statute of Anne, was mostly concerned with people having rights over their creative work. It was frightfully vague by modern standards, but it established the tradition of artists have some ownership over their art that we inherited today. The US Constitution addressed intellectual property directly, saying, quote, "To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries." This is later refined into both law and regulation under the jurisdiction of the US Patent and Trademark Office and the US Copyright Office. In some other traditions, like Continental Europe, authors have rights over their work that are considered an inherent or moral right. In the US, though, we don't really do that. We treat intellectual property as the domain of law. You get only the rights granted to you by law and nothing else. Keep in mind, as I'm going through all of this, that this entire system is a patchwork of new laws updating the old. In many situations in IP law, in fact, in almost all of them, the only true answer to any question of what if is only reachable by a court and by a judge. Everything I say would have to have a dozen except fors if I was being 100% accurate, so just try and give me a little bit of latitude if you know some of the details. And I'll say this one more time. If you have specific questions on any of this, please speak to an attorney. But onward to the adventure in the four main branches of intellectual property. They are, briefly, copyrights, protecting creative works like novels or source code. Patents, protecting inventions like the latest consumer gadget or algorithm. Trademarks, protecting brand recognition. And trade secrets, protecting the right of commercial entities to keep secrets. Copyright is the most common form of intellectual property, so let's start with that one. Meet Bob. Bob wrote a book. Bob sells copies of that book to a bunch of people that want to read it. This is fantastic. But someone buys a copy of his book and then start selling it themselves. This means that Bob will probably not want to write another book. So if we want Bob to write more books, we need to prevent this from happening. And thus was born the idea of copyright law. There are 6 rights that are exclusive to copyright holders, but 3 of them are about the rights of public performance, and you can't really perform software, so we're mostly going to worry about these 3. The first is the right to make copies of a work. The second is the right to make new works based on the old work. And the third is the right to sell or give away, because in most intellectual property law, giving something away for free still counts as a sale, the work to the public. If you own the copyright to a work, only you get to do these 3 things. The biggest piece of copyright law in the US is the Copyright Act of 1976. This basically called a full do-over on the entire US copyright system. It defined those exclusive rights we just saw. It said what could be copyrighted and defined what exceptions to copyright would exist. The biggest change, though, in this new law was that copyright became completely automatic. Before 1976, there was a whole complex song and dance where you had to register your thing with the Copyright Office and renew it periodically. All that is completely out the door. Since 1976, the moment you create something, it is under copyright protection. But it does have to qualify for copyright protection first. This means it has to meet 3 main qualifications. The first, it has to be original, meaning you created it, it's a new work, you didn't get it from somebody else or steal it. Second, it has to be something that's called a work of authorship. There's a whole set of categories of these, but in general in technology, we only run into 2 things that count as works of authorship: literary works and graphics works. Yes, this means that as far as a law is concerned, your source code is exactly the same as a novel, but that counts as a work of authorship. Third, it has to be fixed in a tangible medium. This means that, for example, a dance performance can't be copyrighted, but a video recording or script of it is. Sometimes it's easier to think about what can't be copyrighted. First off, facts are not subject to copyright protection, full stop. Ideas or concepts aren't allowed because they're not fixed into a tangible medium. Anything made by a government employee during the course of their work is not subject to copyright protection, although it may get other protections like national secrecy, et cetera, et cetera. A work has to be creative to count, so something that is a simple arrangement of facts is not generally considered to be copyrightable. For example, phone books are not usually considered copyrightable because they're not creative enough. And finally, there's this idea of useful articles not being copyrighted, something where the form is entirely dictated by the function. So for example, the lines on graph paper can't be copyrighted. However, that last one is in quotes and has a question mark after it because there's a very recent, in the last several months, Supreme Court decision called Star Athletic v. Varsity Brands, where the Supreme Court overturned several hundred years of useful article doctrine and said that yes, in fact, if something that is part of a useful article but is sufficiently creative, it can be considered subject to copyright protection. So that last one's currently a little wibbly. We'll see how it turns out. And the last bit of copyright to define, while we're just figuring out what copyright is how long it lasts. The Constitution specified that these protections should be, quote, for limited times. So I'm going to gloss over a whole bunch of the procedural details between 1923 and 1978, like I said with the whole registration thing. Roughly speaking, anything published before 1923, there is no copyright, it's in the public domain, period. If it was published between 1923 and 1978, it is protected for, at most, 95 years, possibly less, from publication. Works published between 1978 and now, if they are owned by a human being, they get the lifetime of the author and then 70 years after the author's death. If they are owned by a company, they get either 95 years from publication or 120 years from creation, whichever is shorter. So that means you can't just not publish something and claim that it stays under copyright forever. The elephant in the room of copyright term is Mickey Mouse. Disney is certainly not the only company that lobbies for increased copyright protection, but for better or worse, the Copyright Term Extension Act of 1998 is deeply associated with the company. As it stands, almost nothing has entered the public domain since 1923, and the impact on the arts is still being felt today. However, it turns out that 95 years from 1923 happens to be 2018, so we may see some changes here very soon. Either there's going to be a very rushed copyright term extension law again, or we'll finally start seeing things enter the public domain for the first time in a long while. So we know our rights. We know that we qualify for copyright because software is a work of authorship and tangible medium, et cetera, et cetera. The next thing you usually see when you're talking about copyright are these 3 words: all rights reserved. This is an explicit statement that you, the owner, are keeping all 6 of those exclusive rights for yourself. No one else gets to use those rights. But also remember, this is the default state. You don't need to say all rights reserved. It's the default. If you make a work that's subject to copyright, by default, you get all 6 of those rights and no one else does. But it is worth remembering that there is this concept of work for hire. Anything that you do at work that is you are directed to create by your employer and that you are paid to create automatically belongs to your employer. This varies a little bit state to state, and very often your employment contract will have more specific provisions that override this. But generally speaking, if you're a full-time employee, everything that you make belongs to your employer. Copyright belongs to the employer. I'll cover both of these in greater detail later on, but briefly, a license is a contract between you, the copyright holder, and someone else that you are giving them limited use of some of your 6 exclusive rights, usually subject to certain terms and conditions and possibly in return for payment. In open source, which is where we care about licenses a whole lot more in most cases, the license is between you, the copyright holder, and a generic anyone that wants to use those rights. Fair use is an exception to copyright that allows you to violate someone else's copyright, to infringe on intellectual property, subject to certain conditions. For example, I used that copyrighted Mickey Mouse graphic on the last slide as part of a comment and critique on Disney, covered under fair use. They probably can't sue me. So that covers the overall concept of copyright. Let's look at a specific legal case. Oracle America v. Google. This case had 3 major claims of copyright infringement. We're going to gloss over the actual case because it was hilarious, but way too much to go into. Roughly speaking, Oracle claimed that Google infringed on the range check function in their Java implementation. They infringed on the structure of the Java API as a whole, and then they infringed on a whole bunch of miscellaneous code and documentation files. There's also some claims around a couple patents, but we haven't gotten to patents yet. So let's just look at how these decisions played out. The first jury found that the range check function and the overall Java API were infringing, but that the documentation and other code files were not. They were deadlocked on if the API infringement counted as fair use, so they didn't reach a verdict there. The judge in the first trial overturned 2 of those decisions. First, he overturned the other code and documentation files, claiming that they were infringing as a matter of law, and that the APIs were not infringing, the overall structure of the APIs were not infringing, because in his words, an API is a system or method of operation and is therefore not a work of authorship and therefore doesn't qualify for copyright protection. Oracle appealed this decision, because of course they did, and the appellate court overturned the original judge. They said that APIs are a concrete statement in a tangible medium, because they're in source files, and that APIs represent creative work, and thus APIs are copyrightable. But that first trial hadn't reached a complete verdict on all of the if the infringement is fair use stuff, so a second trial was needed to answer that question. And it turns out that the second trial did in fact come back with yes, APIs can be copyrighted as a matter of the appellate judge, but that infringement is fair use. So as it stands today, in modern intellectual property law, APIs may be copyrightable, but it is very likely that you cannot enforce that copyright if anyone using them or copying them is subject to fair use. Why do I bring this specific case up? Because it shows that copyright is really, really hard. I said before that you can only get these answers from a judge or from a court, but even the court system is having a lot of trouble figuring out how to apply the concepts of copyright law into software and technology. But we've only got a limited time, so let's move on to the next major type of intellectual property, patents. Whereas copyrights protect specific tangible works, patents protect inventions. I'll contradict this a little bit later when I get down into the details, but roughly speaking, a patent covers the entire idea of invention, of a given invention, not a specific implementation of it. But similarly to copyrights, patents give you an exclusive right. Specifically, it's this right to exclude. This means that you can prevent anyone else from using your invention. But notably, it's a negative right for others, not a positive right for you. Being granted a patent doesn't necessarily mean that it is legal or wise or even possible to build your invention. It just means you can prevent anyone else from doing the same. For an invention to be patentable, it has to meet 3 criteria. First, the invention has to be useful, especially in technology. This is usually the lowest bar to cross. It means that you can't patent, for example, a perpetual motion machine or something that does exist but doesn't actually do anything, like some arbitrary structure that is novel but doesn't do anything, doesn't perform any function. Next, it has to be novel, meaning the invention didn't exist previously, which in the concept of patents means that your new patent application is written specifically enough that it does not cover any pre-existing inventions. And finally, it has to be non-obvious. That means that at the time of invention, it would not have been obvious to create this invention to a, quote, person having ordinary skill in the art. This is often the most contentious because patent examiners aren't experts in every field, especially technology and software. So they mostly have to take the patent applicant's word for it when they say, of course, this was not obvious. This means that in the end, they really rely on the court system to post hoc decide whether something was non-obvious at the time or not. But if you meet all 3 of these criteria, you get a patent, right? Not always. Just like we saw with the works of authorship for copyright, there's certain categories of things that you have to fall into in order to be patentable. These are the 4 top-level ones, although there's hundreds of subcategories under each of these, as well as completely separate patent systems for plants and designs. But roughly speaking, anything to be patentable has to be one of these 4 things. Or again, like we saw with copyright, let's reverse this. So this means that you can't patent a pure idea. I did say that patents cover ideas of inventions, but you have to actually have a physical invention of some kind in order for you to qualify for a patent. Similarly, you can't patent universal absolutes like laws of nature or mathematical formula. However, you can patent novel mathematical algorithms, and the difference between a formula and an algorithm is real fine at times. Similarly, you can't patent anything that is a naturally occurring substance or process, but you can patent a, say, refining process or manufacturing process that has starting points in natural materials. So what's an extraction process and what's a natural material, very fine line. But the fundamental theory of patents, why do we do this? It's this concept called enabling disclosure. We want more inventors to create more awesome inventions. So in return, if you invent something, you get 20 years in order to turn a profit on it. But the quid pro quo is you have to document your invention so thoroughly that any person in the same field can recreate your invention after those 20 years are up. So inventors get to make their buck, and over time, after the patents expire, society gets more inventions to draw from over time. The target of enabling disclosure is the same person having ordinary skill in the art, which we saw back in the non-obvious requirement. This is called a legal fiction. It's a made-up person or concept that exists to illustrate certain points in law. But because no actual specific person having ordinary skill in the art exists, this means we don't really have a hard and fast rule of what qualifies as ordinary skill. So again, the courts kind of have to make this up as they go, and they have maybe not done such a great job of what qualifies as ordinary skill for software developers. Like I said, patents last for 20 years. This is a lot shorter than copyright, intentionally. There are certain extensions that can exist to this if the filing process or review process takes a very long time, or if you filed your patent before 1995 for some reason. But usually that's only an extra year or two on your patent. However, some companies have figured out ways to slightly tweak a design and refile it as a new patent, potentially getting another 20 years, so you get 40 or 60 total. Those companies are evil and they should stop, but it is a thing to worry about sometimes. Because the novelty of a patent is determined by your patent filing date, so if somebody else comes along with the same patent, you check the filing dates, and whoever got there first is considered to have been the novel one. You generally want to file as early as possible. One thing to keep in mind is that there's an idea of something called a provisional application. This is a document that you file with the USPTO that is very similar to a patent. It's written as concretely and specifically as you can get, but it doesn't have to be the full application. You're allowed to follow up anytime within the next year with the full application while retaining the earlier filing date from the provisional application. Another tool in the arsenal of patents is this idea of a defensive publication. This is a document generally written as specifically as a patent, although sometimes not if you can't figure out how to do it, that creates prior art. So this establishes the novelty of your patent without having to pay the tens of thousands of dollars in fees and legal costs to actually file it. This means that if you or your company or your open source project develop something that you think is novel enough for patent protection, and you don't want someone else patenting it, thus potentially screwing you over, you can file a defensive publication and prevent anyone from patenting it in the future. As of 2013, however, you can't file these directly with USPTO, so you have to file them through a bunch of unrelated ancillary organizations, either in, say, a scientific journal or an open source newsletter, maybe. If you look up defensive publications on Google or talk to a patent attorney, there's a whole bunch of organizations that will help you file these. Within the tech industry especially, patents have become less of a way to defend inventions and more of a weapon. So many companies have these enormous patent portfolios, say, Google, as an example, they bought all of Motorola basically just to acquire Motorola's patents. And these large companies, they set up cross-licensing agreements with other large companies, and the cross-licensing agreements are such that if either company sues the other, the cross-licensing is voided. What this does is effectively creates a stalemate. I call this mutually assured patent destruction, in the same way as we had in the Cold War, where no one can actually use any of their patents. This is a stable solution. It's working okay, but it's not really a system that anyone's super happy with at the moment. And this leads directly into what are called non-practicing entities. These are companies that hold a patent, but they don't actually do anything with it, hence the non-practicing part. They mostly just use it for licensing to other companies or lawsuits. Not all NPEs are bad. In fact, NPEs are the primary way that new ideas and inventions get from academia out into industry, but they're so often misused that you may know them by another name. Patent trolls exist only to try and squeeze money from companies by threatening or occasionally filing patent infringement lawsuits on things that probably everyone in this room would subjectively agree are overbroad patents that should probably have never been issued in the first place. However, going to court on even an incredibly frivolous lawsuit costs thousands or tens of thousands or hundreds of thousands of dollars, so a lot of people will sometimes just pay these patent trolls to go away. However, it's going to be a subjective decision what is a patent troll trying to extort money out of people versus an underdog standing up for their legal rights. You'll have to decide which is which on an ongoing basis, but both of those definitely do happen. So it's time for another case law example. I'm not going to claim Alice is a patent troll, but this is definitely an interesting case related to non-practicing entities. So Alice Corporation versus CLS Bank International. The case revolved around 4 patents held by Alice Corporation covering computerized versions of payment escrow and loan management systems. Alice claimed CLS Bank was infringing on their patents. CLS Bank counterclaimed that their patents were invalid. I'm going to skip over the whole appeals process. Basically, Alice lost a whole bunch of times and appealed all the way up to the US Supreme Court. In the majority opinion, the US Supreme Court held that not only were all 4 of those patents invalid, the entire area of patents that Alice was talking about are invalid. In short, this new decision says taking a non-patentable abstract process or business process and just saying on a computer does not make it patentable. This has led to many thousands of patent rejections. This graph is summarized here, patent rejections by quarter. As well as hundreds of patent invalidations. If you divide out that graph, that's over 100 rejections a day, specifically citing Alice as the reason for something to not be patentable. To call this a big deal in the patent world is an understatement. The vast majority of software patents now have a target on their back. The tech world has been divided into the pre-Alice and post-Alice eras, with a lot of people somewhat unhappy that things have changed. There's actually a lot of people calling on Congress to reform Section 101 of the Patent Code in order to reallow these kinds of software patents because they want their mutually assured patent destruction stalemate back, but we'll see how things go. This is relatively recent as intellectual property matters go, so still waiting to see how it shakes out. But again, limited time, so let's move on to trademarks. Roughly speaking, trademarks, as well as service marks, although I'm just going to say trademarks from now on because trademarks and service marks are effectively the same thing for all useful purposes, they protect brands. The idea is to identify the source of commercial goods or services so that customers know what they're getting when they buy something. If you buy something that says Coca-Cola on it, you know that you're going to get the same product every time. You're not going to get somebody's discount cola that tastes different. This is a bit different from copyrights and patents. We're not trying to encourage the creation of specific new works of art or inventions. Instead, we're trying to facilitate commerce by allowing customers to know what they're getting. As a concrete example, let's take Wikipedia. The Wikipedia brand has a lot of value. The Wikimedia Foundation has spent a lot of time and money to get good feelings towards it. It's an encyclopedia you trust. It's a thing you like, et cetera, et cetera. So let's say I wanted to get in on that sweet, sweet donation cash. I can't copy the website directly because it's under copyright protection, et cetera. But what if I just name my website my Wikipedia and hope that people are confused and therefore donate to me instead? The Wikimedia Foundation obviously doesn't want that. They've spent all that time and money developing their brand. They want to get the donation rewards. Therefore, they would serve me with a very well-deserved trademark infringement lawsuit. So what can be a trademark? Just about anything, it turns out. Most marks are going to be words, phrases, or graphical logos, but just about anything with a strong brand association can probably be a trademark. This includes, for example, the shape of the classic Coca-Cola bottle or the MGM lion boar. In order to register for trademark protection, you need to demonstrate actual use in commerce. You do this by submitting a sample of your product or a sample of your service to the US Patent and Trademark Office, or by filing an intent to use document saying, I'm about to use this mark in trade, therefore please make sure that no one else starts using it before me. However, if you file an intent to use, you do have to follow up later on to prove that you did actually use this in commerce. Like with copyright, trademark protections are actually automatic. You don't need to register with USPTO, but if you do, you get certain advantages. First off, you can use that snazzy R symbol, which everyone loves. But more importantly, if you register your trademark, you get to start off all trademark infringement lawsuits with an assumption of validity of your trademark. You can just put TM on anything that you are asserting is a trademark, but if you try to sue someone over it, you'll have to start the case by proving that it's a valid mark, that you got there first, that you're actually using it in commerce, all the same steps. So you can save yourself a little bit of trouble if you're going to actually try to enforce your mark by registering with USPTO. Unlike copyrights and patents, which have a fixed term, as long as you're using a mark in commerce, it stays. You do have to re-register with USPTO for registered trademarks every 10 years, but you can do that indefinitely. Roughly speaking, as long as the brand still exists and you're still using it in commerce, you can keep your trademark. I'm not going to go into trademark infringement in full because it's hilariously complicated, even by intellectual property standards. The 8 most common things used to judge whether something is trademark infringement are called these Polaroid factors, after a 1961 infringement case involving Polaroid. But roughly speaking, if a random person on the street, a lay person, would be confused and think that the infringing product is produced by the original brand, that's trademark infringement. Another term that you'll sometimes see in connection with trademarks is trade dress infringement. This came up, Samsung sued Apple over trade dress infringement. Slightly different in goal, but roughly speaking, you consider trade dress and trademarks to be the same thing. And one last word that you may have seen in connection with trademarks is the idea of dilution or genericification. This is the idea that you must actively defend a trademark in order for it to remain valid. This is technically correct, and there are a lot of cases that real trademarks with a lot of value have been lost due to dilution. For example, aspirin and escalator used to be trademarks. But it's not nearly as common as a lot of news media outlets, especially in the tech world, would make you think. As in, there have been less than 100 confirmed cases in the entire history of US trademark law. But, for example, this is why Google continues to insist that they are not a verb. They don't want to lose their trademark to dilution. I'm of the opinion that this is a vastly overblown problem, but I'm not an attorney, so take that as you will. Trademark cases are often a lot less visible than patent and copyright cases, so let's just look at a couple of them very quickly. In 2008, a man named David Cooter made a website advertising his writing and production services. He registered a trademark and he put up a website for Flay Tom writing services. In 2009, a Disney-owned game studio decided they wanted to rebrand themselves to the name Flay Tom. This means that they tried to register a trademark and got refused by USPTO, saying somebody else already has that name for a related service, you're not allowed. This got taken all the way up to the Federal Circuit appellate courts, and the eventual decision was that the original guy, David Cooter, he did not use his mark in service. It turns out that just advertising services does not qualify as use in commerce, and thus his trademark was invalidated. So I think to keep in mind, just because you say this is a name that I want to use in commerce, unless somebody actually buys it from you, it doesn't count. A decision from the Federal Circuit again, a company called Newbridge Cutlery Company tried to transfer in a mark from the Irish Trademark Office, citing they wanted to sell their, I think it was knives and candles, under the trademark Newbridge Home. This was originally refused because you can't trademark geographic location. For example, New York Pizza is not a trademarkable name. However, the federal appellate courts decided that most people wouldn't know that Newbridge was a place in Ireland where the company happens to be located, and therefore the mark was allowed. I mostly mention this because it's an excuse to bring up WIPO, the World Intellectual Property Organization, which is a division of the United Nations that deals with international IP issues, as well as enforcing the roughly 24 treaties that cover intellectual property internationally. I don't have the time or expertise to go into all of these treaties, but roughly speaking, these allow limited use of foreign intellectual property in other countries. So, for example, this is why you can't take a book by an American author and start selling copies in France. But these are all hilariously complicated and subject to about a dozen local rules, so talk to an attorney. Back to trademark cases. This one's just sort of fun. A company called DataPipe tried to trademark the phrase "your cloud," and the trademark office actually recognized that the term cloud has become a general industry term and that they were not allowed to claim it. So that's nice. Fairly simple case, but hilarious. A Maryland State Senate candidate named Steve Hershey attempted to use the same branding as the Hershey Company in the form of the same fonts and colors on his campaign signs, and the trademark office had to twice tell him to stop, and that is in fact not allowed. This one's just sort of weird. A maker of fancy watches that does not sell via Amazon, they're too fancy for that, they sued Amazon because if you typed their name into an Amazon search box, it would come back with other watches that you might want to buy, but not theirs because they don't sell on Amazon. A long time ago, there was this thing called initial interest confusion doctrine, where you don't have to necessarily be infringing on someone's trademark on the thing you're selling itself. If you're using someone else's trademark just to generate sales interest, that can be trademark infringement. But because of the plethora of search engines and automatic discovery systems, this has kind of fallen out of favor. It hasn't really been used since the early 2000s. But for some reason, initially the lower court sided with Amazon. Multi-Time Machine appealed, and the appellate court originally sided with the watch company, citing this doctrine. No one's entirely certain why. Amazon asked for a rehearing, which they were granted. They re-explained their case, and the appellate court abandoned their use of that doctrine. This fortunately went the way that it should, and Amazon was not found to be infringing, but this does mean that some people are still using this weird initial interest confusion doctrine. Again, maybe ask your attorney if this is a thing you need to be worried about. And a final case, Pinterest tried to sue a small travel booking website called Pintrips, alleging that they had exclusive control over the trademark of the use pin as a verb and pin in their name. In a scathing 44-page decision, the California judge handed down that they in fact can't do that the term pin is widely used in the web application industry, and that they had tried to apply for something called famous brand status, which gives you a bit of sort of automatic trademark protection. And the judge said that no, Pinterest doesn't get to qualify because they are not widely known enough. So this is just nice, shows that the biggest party and the biggest wallet doesn't always win. And very, very briefly, because it's real simple, trade secrets. Very simply, trade secret law is for things that you don't want to disclose. You don't want to register these as patents, or they aren't subject to copyright protection, but you want some legal basis for keeping them secret. Of course, if a trade secret is leaked, you can't make it not secret. The law isn't magic, but you can at least sue the leaker and have legal grounds for asserting that you do own it. The canonical example for this is the recipe for Coca-Cola. Recipes are just as a subject matter not counting as a work of authorship, so therefore they don't qualify for copyright protection. You can't patent a recipe because it's not really an invention. You can't trademark a recipe. So trade secret law is just a legal basis for things like that that you want to keep secret because that recipe is extremely valuable to the Coca-Cola company, but that you don't have any other way to count it as intellectual property. All right, so that's the 4 main types of intellectual property. But why do we do all of this? Some of it's for purely capitalistic reasons, as outlined in the Constitution. We want people to make more art and commerce, and et cetera. But there's another reason too, and it's the one that's a little bit closer to my heart, to improve the public domain. Put literally, the public domain is the collection of all works in the world that are not under any form of intellectual property protection. And to explain the value of this, we need to talk about the commons. This usually comes up when we're talking about the famous tragedy of the commons theory, where if any resource is 100% communal, it'll eventually be depleted due to overuse. The original example was shared livestock pastures leading to overgrazing because no one cared enough to maintain those pastures. But here, the resource we're really caring about is the collective creativity and inventiveness and artistic expression of everyone in the world, or at least in this country. If their creativity was communal, they didn't get any benefit from their own creativity, they would have no reason to exercise that creativity. So we give them limited rights over their creative products to encourage them to create more awesome things. But in general, we want people to give that back eventually. From the writings of Homer to the paintings of Hokusai to the polio vaccine, these eventual public domain works form the scientific, cultural, technological, and artistic basis for our entire world. They act as inspiration to future generations and shoulders for all future works to stand on. Your works can be given over the public domain from the beginning, but this can be difficult in certain jurisdictions. So the Creative Commons has a document, it's not really a license per se, but it's a waiver of rights called CC0. This is a document that says that you as the author are giving up all rights over your work as much as possible in every jurisdiction. So if you're working on something that you want to belong to the common heritage of all humankind, consider using CC0 to waive all of your rights over it. All right, but back to things more directly related to software, let's talk about licenses. Why do we put a license on software in the first place? If you remember back to copyrights, all of those rights stay with the copyright holder. So roughly speaking, this means if I just put some code up on GitHub and don't put a license on it, no one can copy it, no one can use it, no one can make derivative works from it. The original and probably still most common form of licensing in software are commercial licenses. You give the copyright holder some money, they give you a license in return that gives you usually fairly limited rights. For example, you can copy it from an install disk onto your computer, but you can't make derivative rights, you can't give it away to the public, etc. Usually this is wrapped up in the end user license agreement, or EULA, along with a cornucopia of other legally dubious contract clauses. But the case most of us care about is open source software. So like I said before, instead of a EULA between a purchaser and the copyright holder, this is the generic anyone and the copyright holder. The MIT license is about as simple as they come, so let's start with that one. The top of this just says who owns the copyright and when. As I said before, copyright is automatic. We don't need to do this, but we want it clear who owns the copyright, so we're going to put it in this text. Then we take some of our exclusive rights and we say you can use these rights subject to certain conditions. Specifically, we outline the 3 rights that matter for software, being duplication, derivative works, and sale to the public. And then we outline the 3 conditions that you need to meet in order to use those exclusive rights. First is the notice condition. This is the part at the top that says that if you want to use those rights, you need to keep this license text and copyright disclaimer attached. Then we have those 2 yelly parts, which has the other 2 conditions, which are a warranty disclaimer and a limitation of liability. In US commerce law, there's a doctrine whereby products are assumed to be fit for purpose and fit for sale. This just sort of insulates us from those a little bit by saying we don't actually promise that the software does anything at all. Please don't sue us if anything goes wrong. But we put all this together and we get the user allowed to use the software. They get access to enough rights to use the software in exchange for fairly minor requirements. And thus, open source. Yay. Usually after I talk about MIT, the next question is, what about the BSD licenses? They're similarly minimalist to the MIT licenses, or MIT license, but they add 1 or 2 extra conditions to those 3, usually around publicity or advertising, depending on exactly which BSD license you're talking about. Unfortunately, software patents have crashed this party. Being minimalist, both BSD and MIT only deal with copyright licensing, not patent licensing. And even in the post-Alice world, software patents are still enough of a threat that they are a thing that you should be worried about. The first kind of interaction between patents and software licensing is I, or more generally my company, wants to open source something, and we are asserting that there are some patents that we control that are applied to the software. So in order for anyone to actually be able to use the software without getting sued for patent infringement, we need to give them a license to use those patents. This can be done in the main license, but it's also fairly often done via an auxiliary patent grant. This is the Facebook one used for React, which is a whole different story. But the more interesting case is somebody comes to my project, they give me a patch, I love the patch, I merge the patch, everything is great. Sometime later, their legal department rolls up and says, well, actually, that person's contribution was under a patent that our company holds. We're suing you, or worse, we're suing all of your users for patent infringement. As far as I know, this has never actually happened, but a lot of new licenses attempt to prevent this from the start. So this, for example, is the patent grant from the Apache 2.0 license. The Apache license is a lot newer than the MIT or BSD licenses, so it covers trademark licensing, patent licensing, more precise definitions of the rights, et cetera, et cetera. It's also got some contributor licensing text. But like MIT and BSD, it puts very few restrictions on any of the derivative works. It says you have to keep this license on it, but that derivative work can be basically whatever you want. This is as opposed to the idea of copyleft, which was originally outlined by Richard Stallman in 1985. Copyleft licenses, which has become an entire family, are a bunch of licenses that put much more restrictions on those derivative works. So, for example, the GPL is the most famous of the copyleft licenses, which requires that all derivative works be licensed under the GPL or a compatible license, and that everyone that has access to the software has to be given access to the source code and the entire development environment. The conditions of the GPL inspire a lot of fear and confusion, so let's talk about those real quickly. The first is that virality condition. This is the idea that any derivative work has to be shared under a license that is compatible with the GPL. GPL defines compatible as a license which puts no more restrictions on the user than the GPL does itself. Unfortunately, what's not clear is what qualifies as derived work. Now, obviously, if I take some GPL code and I just edit it, that's a derived work, end of story. You have to license that in a way that's compatible with the GPL. The creators of the GPL would like to assert that if you do any kind of software linking, either static or dynamic linking, with a GPL library, that on the fly creates a new derived work, and therefore the licensing must be compatible. However, this is not always legally provable. The GPL team at the Free Software Foundation did actually, or GNU project, did create a second license, the lesser GPL, which makes it very clear that linking does not create a derivative work. So in this case, the only thing that needs to be viral is if you directly edit it. But with the GPL itself, they still like to assert that linking creates a derived work. Oddly enough, the most applicable case law in this thing comes from Galoob Toys via Nintendo of America in the mid-90s. Galoob made the Game Genie. I don't know if anyone remembers. This was a peripheral that let you do some basic cheat codes into your Nintendo games. Nintendo tried to assert that because they were dynamically linking against the code of your NES and SNES cartridges, these created derived work, and therefore they were infringing on Nintendo's copyright. The court held that no, this is not the case, and that because there's no concrete work as the derivative of this, it doesn't count. It's not clear in software exactly how this would apply. It's possible that static linking, for example, would create a derived work, but dynamic linking wouldn't. Regardless, it seems pretty clear to me, but again, I'm not an attorney, so this is not legal advice, as well as a lot of other people that are attorneys who you can go read about online, that the GPL is probably much less viral than its creators like to make it out to be. It does not appear that they can probably legally enforce the idea that dynamic linking creates a derived work, so that wouldn't actually activate the virality clauses. All right, I'm running out of time, so I gotta go fast. The other main bugbear of this is code sharing. So this is the requirement that anyone that is using a GPL tool has to be given access in order to modify it. So that means they need the source code, possibly any build tools. If you're using your own custom language, you have to give them the language interpreter. Whatever they need to be able to modify the code and recompile it and run it themselves, you have to give them. However, with the GPL itself, this only applies to people with access to the binaries. So for example, if you have a network service that is GPL'd, users of it over the network do not need to be given access to the source code. There's a second license, the GPL, that does. Mostly I've been talking about licenses for source code, but there are other licenses for things that aren't code. The Creative Commons group maintains a whole fleet of these licenses that allow you to very carefully dial in exactly what rights you want to give the person and what requirements you want to put on them. And they also maintain that CC0 thing that's not technically a license, but close enough. Here I get to put my finger on the scale a little bit and give my personal opinions, but again, not legal advice. I take a hard stance that there's really only two licenses that make sense to use anymore, GPL v3 and Apache 2.0, which is based entirely on whether you want copyleft protections for your software or not. And if I can go a little bit further, I'm firmly in the permissive license camp. I recognize that there are definitely cases where copyleft and GPL stuff matter, but chances are your software isn't one of those. All right, and I've got 47 seconds, so let's talk about CLAs real fast. CLA is a contract between a contributor and the project that acts sort of like a license, but instead of covering the user, it covers contributions to the project. These read a lot like a license, but they are covering instead, or usually in addition, that you have a legal right, so you either own the copyright or have permission from the copyright holder, a legal right to give this contribution, and if it is covered under any patents, you are giving a license to those patents. So this is sort of like what we saw in the Apache license, but can be applied to any project. Some project CLAs have been replaced by the developer certificate of origin process. This is similar to CLAs, but instead of agreeing to one contract once, you agree to a much smaller contract, but on every commit. To the best of my knowledge, there are 0 legal cases anywhere in the world that involve either CLAs or the DCO, so the best advice here I can give is that a lot of very good lawyers that I trust a lot have decided that CLAs or the DCO process are required to safeguard their projects, so probably listen to them, and again, talk to your legal department if you have one. And we do not have time for my bonus slides, I am sorry. So skipping all the way to the end, to the wrap-up. So quickly, what we talked about here, we talked about copyrights and how they protect new artistic or creative works. We talked about patents and how they encourage novel inventions. We talked about trademarks and how they facilitate commerce. We talked about trade secrets and how they let companies keep secrets. We talked about the public domain and the value of the commons. And we talked about software licenses and how they allow sharing some of those exclusive rights that copyright and patents give you so other people can use your software. And a couple of resources for your own IP journey. The Cornell Legal Information Institute has a great web-based copy of as much of US law as they can manage. If you saw, there's USC references in my slides. If you want to look any of those up, those are US code references. You can do that on the LII website. The book IP and Open Source by Van Lindbergh is a great discussion of everything that I've gone over here today and way, way more. The USPTO website has lots of great educational resources and is also home to the TESS trademark search system. So if you want to go, if you want to go see if a trademark is taken or research someone's trademarks, you do that on the USPTO website. The USPTO website also has a patent search system, but Google made one called Google Patents, which is often easier to navigate and a lot faster. And finally, the This Week in Law podcast is a great way to keep up to the new happenings in the IP world. So thank you very much. You can find all these slides at current.net/talks, along with all my other talks. And we don't really have any time for questions, but I'll hang out down there if anyone wants to come talk to me. Thank you.
All right. Thank you, Noah.